This Honorable Court of Criminal Appeals is now back in session. Please be seated.
All right, thank you. Madam Clerk, call the next case, please.
State of Tennessee versus Ambreia, Tavaris, Washington.
Morning again.
Morning again.
May it please the court, Brennan Wingirter with the Public Defender's Appellate Division here for Mr. Washington, the appellant. And again, I've reserved 4 minutes for rebuttal from Madam Clerk.
4 minutes.
Thank you, Your Honor.
All right.
Mr. Washington was convicted of attempted first-degree murder involving serious bodily injury after he shot Ryan Murphy 1 time in the lower abdomen. Here again, the state presented no medical proof, no expert testimony, and rested solely on the victim's lay testimony to establish his injury in this case. Mr. Murphy testified that he initially did not realize he'd been shot. He thought it was just a graze. There was very little blood. He was not in any pain. He can be seen on body camera footage immediately after the shooting, standing, talking to bystanders, smoking a cigarette, sort of casually at the scene immediately after. He was transported to the hospital eventually, where he learned, in his words, that the bullet had sort of fallen on his intestine. He did undergo a short surgery to have the bullet removed, and they had to take out what Mr. Murphy described as maybe 2 inches of his intestine. In this case, again, as I argued earlier this morning, our position is that this was a bodily injury, not a serious bodily injury, so the remedy would be leave the attempted first-degree murder conviction intact, but remove the serious bodily injury enhancement. The state's theories for serious bodily injury are threefold in this case. Number 1, a substantial risk of death. Number 2, a protracted or obvious disfigurement. And number 3, the one we discussed earlier this morning, the protracted loss or substantial impairment of a function of a bodily member or organ. As to the substantial risk of death way to establish serious bodily injury, here the state seems to be relying primarily on Mr. Murphy's fear of death. He said at one point he was afraid he was going to die. On that point, though, Your Honors, the case law is clear that the victim's fear may be taken into account with the totality of the circumstances, but there has to actually be a substantial risk of death for serious bodily injury to be proven on that prong. And here we have Mr. Murphy's one statement of, I thought I was going to die, but he also testified.
You don't think someone gut shot is not serious bodily, that's not a serious risk of death?
Per se, no, Your Honor. And that is effectively, again, to go back to that Farmer case from the Tennessee Supreme Court, that is effectively what we're saying here. Serious, if the law is not that.
Farmer didn't require surgery.
That is true, Your Honor, but what not necessarily on the facts, on the law is what I'm referring to with Farmer, I apologize. On the law with Farmer, what the Supreme Court said was we cannot look to what could have occurred. We are not talking about the potential injuries. We're talking about what did occur and what are the actual injuries.
And removing part of the intestine, you think is comparable to what happened to Farmer?
No, Your Honor, and I want to be clear, I don't think it's necessarily what I think, again, it's not about what I think is substantial or not. If the state had called any of the doctors who performed that surgery, and any of the doctors had been there at trial and said, when we did this surgery to remove this bullet and we had to take out a portion of his intestine, there was a substantial risk that he could have died, or this was a very dangerous surgery, or this was any of that testimony would have gotten the state where it needed to get. But Mr. Murphy saying they took maybe like 2 inches of my intestine, he refused all pain medication after the surgery, and he's almost immediately giving his statement to police after the surgery. That in itself is not does not prove the substantial risk of death. I'm not saying it can never happen, and certainly, as Justice Koch described, a massive gunshot wound to the heart or to the abdomen. Certainly,
This was a wound to the abdomen.
Correct, Your Honor. It was not what Justice Koch's language was, a massive gunshot wound to the heart.
So what constitutes a massive gunshot wound?
I think that's up to the state to prove, and this is not one.
Is it up to the jury, though, ultimately, to listen to the charge? The judge gave the charge.
That's correct.
Serious bodily injury and bodily injury.
That's correct, Your
And
Honor.
the jury listened to the facts of the case and decided this was serious bodily injury.
That's correct, Your Honor. Under the sufficiency standard, however, when we have the statutory definition of substantial risk of death and there's no proof that Mr. Murphy was ever at a substantial risk of dying, there is no proof that he had a protracted or obvious
So
disfigurement.
the jury couldn't conclude that from the testimony and the evidence of what happened to the victim.
Correct, they could not. In this case, I'm saying if the state had put on any level of additional proof about the extent of the injuries, if there's any medical testimony.
I was going to ask, it sounds like both of these cases this morning, you're kind of arguing that the state ought to have to put on more proof and even in the way of actual medical proof versus just the witness, the victim's lay testimony about what happened to them. I'm not saying that wouldn't be a really good practice and recommended, but I don't think anything in the law requires that.
That's correct. And I want to be clear, I'm not asking this court to say it is required. Our position is, especially when and I think Justice Koch says it best in that concurrence, when you have an injury that's maybe somewhere in between the extremes, if the state is going to prove its case beyond a reasonable doubt, it may need to introduce that kind of medical testimony. That's what we're saying here. If there had been any kind of medical proof in either of these cases, we probably have no argument, just to be honest. But I think they could have put on, as some of the case law that they cite, both from Tennessee and other states, if an expert had put up pictures of x-rays, for example, and discussed those, if there had been pictures of Mr. Murphy's wound, either internally or externally, if he had showed the jury his scar from the surgery, any of those things, this court has said before, that's good enough. But we don't have it in this case. So our position is not that medical proof is required. Our position is that medical proof may be necessary for the state to carry its burden beyond a reasonable doubt when we're under a sufficiency standard. In a case like this one and the one this morning, where it is close, where there is a question of, this person is not suffering the massive gunshot wound to the heart or on the other side, a graze. And actually, in this case, Mr. Murphy did testify he thought it was just a graze initially, which makes it even more complicated when the victim's own testimony is he didn't realize he was shot. He was not in any pain. There wasn't a lot of blood. And then we have the surgery, but the surgery to remove the bullet, this court has said, surgery by itself is not enough. Being unconscious during surgery is not enough for serious bodily injury. There has to be something more. And in this case, we just don't have that something more because the state did not put on any additional proof. I want to touch on a few of the cases that the state has relied upon. We went through them pretty thoroughly in the reply brief, but again, I just want to point out when the court is looking at these prior cases to compare. I think it is very important to look at, as I said this morning, the whole picture. I don't think it's fair to isolate, well, did this person stay 1 week in the hospital? Did this person stay 1 day in the hospital, 3 weeks? I think we have to look at the whole proof. And in all of the cases, as we went through in our reply brief, all of the cases cited by the state, there are more facts there that make those cases different than this one. There's either medical proof involved in the other cases, there are additional injuries that were involved. In some of them, the analysis was simply not on point for the case that we have here. So I would encourage the court to not look at, not sort of cherry pick different facts out of those prior cases, but when we're talking about the legal standard for serious bodily injury, we have to look at the injury that actually occurred. We have to look at the proof that the state actually put on at trial. And in this case, it simply was not enough. On the protracted loss or substantial impairment, since we talked about that this morning as well, in this case, again, I would encourage the court to remember that the law requires a loss or impairment to a function of a bodily member. So I want to be very clear that just removing 2 inches of the intestine, that in itself does not meet the legal definition for substantial bodily injury, or serious bodily injury. The prior cases on that point, and the Hill case, there are 2 Hill cases cited in the briefs. One of them is from Tennessee. The Hill case from Tennessee, I think, perfectly captures what would be enough for the state to prove its case? The victim was shot in the abdomen, and he testified that he had problems using the bathroom, problems with his bowels, he had pain, he had to use stool pills afterwards. In Cunningham, a similar case, the victim testified he had to use a colostomy bag for 6 months. Those are protracted or substantial impairments to the function of the lower intestine.
What about having to have surgery again to have scar tissue removed from the intestine?
So that, Your Honor, the state has not appeared to argue that that's part of the injury, and in our position, it's not part of the injury at all. Again, we're talking about that's a surgery, which in itself is not serious bodily injury. And if they have a second surgery, which Mr. Murphy did not provide very many details about that, but how involved it was, again, no medical proof. So we don't know what that surgery entailed. It certainly did not, the record certainly does not bear out that that surgery caused any substantial risk of death or if there was any additional complications there. So again, the function or the use of the purpose of the intestine is what's important, and we don't have any testimony from Mr. Murphy that he suffered from any of that like we have in the prior cases that the state has relied upon. If the court does not have any other questions on the serious bodily injury, I did want to address the, as I said, both cases have a procedural issue. The procedural issue in this case relates to the untimeliness of the motion for new trial. It was about 2 days late, filed by trial counsel. No one noticed, I think. The trial judge ruled on the merits when it should not have. On appeal, I did not even catch that until we had already been in the briefing stages here. So in the brief, I acknowledged to the court that the motion for new trial was late. That waived about 15 issues for the appeal, which is why we're only here on sufficiency in sentencing. And the state correctly pointed out that because the motion for new trial was untimely, the notice of appeal was also untimely, which no one had caught. And I just wanted to acknowledge to the court, I have not yet filed a Rule 4 motion to accept the notice as untimely. I plan to do that today. I thought it, and this may have been wrong on my part, I didn't want to confuse the clerks, and I did not want to file that motion too early where it might be decided by some judge other than the panel. I wasn't sure how the motions judge would work. So I do plan to file a Rule 4 motion to accept the notice of appeal as late filed after court today. So I just wanted to make your honors aware of that. And that would relate to the, again, waiving the timeliness and the interest of justice. And I think the record pretty well bears that out. And of course, I'll submit my affidavit to that effect as well. If there are no further questions, we would ask the court again to leave the conviction in count 1 intact, but to remove the serious bodily injury enhancement. And I'll rest on the briefs as to sentencing. Thank you, Your Honors.
All right, thank you. All right, General, is it mentioned?
Yes,
Is that how
sir.
you pronounce it?
Yes, sir, that's
All right.
exactly right.
Good morning to you.
Good morning, and may it please the court, Joshua Minchin on behalf of the state. On June 10th, 2021, appellant Ambreia Washington pulled out a revolver and shot Ryan Murphy in the abdomen from about 5 to 10 feet away. He was taken to the hospital and underwent emergency surgery to remove a portion of his intestine, as well as the bullet that had remained in his body. The evidence and case law support the conclusion that Mr. Murphy suffered a serious bodily injury and that the trial court did not abuse its discretion in ordering consecutive sentences. In its brief, the state did raise the alternative argument that was addressed by my friend from the other side at the end. Sounds like she will be filing a Rule 4 motion. As far as the substance of that issue, I'll rest on the briefs unless there are any additional questions from you all at this time. Otherwise, I'll move on to address the serious bodily injury issue, and then, time permitting, the consecutive sentences as well. So Ryan Murphy suffered a serious bodily injury in 3 independent respects. First, substantial risk of death. Second, protracted or obvious disfigurement. And third, protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Now, I do want to say it seemed like my friend from the other side was sort of equivocating as far as what the state is required to provide here. On one hand, saying that there's no requirement for medical testimony, but then also saying that in this case, there did need to be medical testimony. However, in looking at Farmer and looking at any opinion from the Tennessee Supreme Court or from this court, there is no requirement that there be medical testimony. Lay testimony is sufficient, particularly where, as here, it's uncontroverted. There's no reason to doubt the veracity of Mr. Murphy's statements with regards to the injuries that he
Well,
sustained.
what about when it is just really a close call like that? And we all know these cases are all, very fact-intensive, and we decide them on a case-by-case basis because of that in a lot of ways, or the jury does, for sure. What about when it is just a really close call and the state only relies on the victim's testimony?
Yes, Your Honor.
And we just don't have a lot to go on to prove, what we do have in the definitions about serious bodily injury.
Yes, Your Honor. To that point, obviously, I think it would be a best practice or a better practice to include that sort of testimony. The state certainly doesn't disagree that having testimony to that nature would have been helpful. It certainly would have. However, it's the state's position that in this case, based upon the injury that occurred and what we have here, that it was not required, that a rational fact finder could find that there was serious bodily injury, starting off with a substantial risk of death. And kind of looking at that, I think it's important to look at the definitions. Substantial means considerable in extent, amount, or value from Black's Law
What
Dictionary.
proof in the record supports that there was a substantial risk of death in this case?
Yes, Your Honor. I think
That a
first of
reasonable
all,
jury could find that?
yes, Your Honor. First of all, you had a gut shot, a gunshot from 5 to 10 feet away into Mr. Murphy's abdomen. That's different than what we had in Farmer, to your point, Judge Campbell, where in that case you had a straight through leg shot. He went to the hospital. There was no surgery required. He was only there for an hour. He was discharged. Here, you had a gut shot. It was not straight through. The bullet remained in his body. He had to go to the hospital and undergo a multiple-hour, 3-hour surgery under general anesthesia to remove the bullet and to remove multiple inches of a vital organ that he's never going to get back. Those inches, they're gone. And so in that case, he had to then, recover from those injuries. And I think we don't ask jurors to sort of leave their common sense at the door. And I think that it's commonly known and understood that a hole in the GI tract, essentially, or a gastrointestinal perforation, that can cause, that can be deadly, especially where it's caused by something like a knife wound or a gunshot wound, where you have something external going into the body. And in fact, this court in State versus Champion held, this is from 2019, there the record, the victim was shot in the abdomen, underwent surgery, and was hospitalized for a week. Here, the record indicates that Mr. Murphy was shot in the abdomen, underwent surgery, and was hospitalized for at least multiple days. And there, here, the court held, quote, "A rational jury could conclude beyond a reasonable doubt that shooting a gun at the victim's torso would have been reasonably certain to cause death." That's essentially the exact same thing that we have in this case. And so the court looks to Champion for that, as well as the Hill case that my friend from the other side cited. There, although the injuries were more significant, what the court held there was a gunshot wound to the upper torso of the body, almost without fail, constitutes a substantial risk of death, given the number of vital organs in that region of the body. And it applied that principle to gunshot wounds in the abdomen. The victim was shot in the kidney and stomach, located in a very similar spot as the intestines, in the abdomen, as we have here. So I think both of those cases support the proposition that a gut shot that causes a permanent loss of a portion of a vital organ, even a small portion, constitutes a substantial risk of death. And other states that have looked at this issue have held similarly. If we look at Thomas versus State out of Alabama, for example, there, the victim was hit in the side by a bullet that exited 1/2 inch from his spine. Now, of note, the bullet didn't hit his spine, it was simply close to it. He was hospitalized for a few days and was able to return to work 2 weeks later. And the court admitted in that case it did not know the location of the entrance wound, and it could not even determine the degree of the injury. But the jury could have inferred that because of the location of the gunshot wound and the fact that hospitalization was required, the wound created a substantial risk of death. Now, in the briefing, my friend from the other side seemed to note that there were cases that were cited that were, quote, not for citation, unquote. But that was simply, I think, maybe just a misunderstanding, as those, both of those cases, I believe, referring to Koale versus State and State versus Manka, were simply not designated for permanent publication. That notation is on the top of every single case in those courts and doesn't affect citation at all. As a matter of fact, Koale versus State has been cited multiple times. And looking at State versus Manka from Nebraska, there we had a very similar issue, a gunshot wound. The victim there was actually very fortunate that no major organs or arteries had been hit, that he suffered relatively minimal bleeding, and there's no mention of how long he spent at the hospital. But the court rested its serious bodily injury holding on the fact that, quote, any penetrating wound to the abdomen presents a substantial risk of death or protracted loss or impairment of the function of any part of the organ of the body, given the organs and arteries that are present there. And that same logic, that's essentially what the court was holding in Champion. And we see that we had not only just a gunshot wound to the abdomen, but one that hit the intestines in such a way that the bullet had to be removed and multiple inches of the intestine had to be removed. We also have protracted or obvious disfigurement here. And I do want to note that it's not protracted and obvious. It can be one or the other, protracted or obvious disfigurement. Here again, looking at the definitions, protract is to prolong in time. Obvious means easily discovered, seen, or understood. And disfigure means to impair by deep and persistent injuries. Or another way to put it would be to mar or to make something no longer able to be completely
So again,
whole.
what's the proof in the record in this case
Yes,
to
Your Honor.
support that?
Yes, Your Honor. And just as a note,
Because
there's,
again, apparently only the victim testified, and there wasn't, not a big fan when I was a trial judge of somebody, pulling up their shirt and showing their scar or
Yes,
whatever,
Your
but
Honor.
there was none of that here.
Yes.
So how do we know that?
Yes, Your Honor. So first of all, I think that the first bit of proof is that the loss of multiple inches of intestine constitutes protracted or obvious disfigurement. I think a rational jury could find that. So Mr. Murphy lost multiple inches of his intestine. It satisfies the protracted definition because it's permanent. He's never going to get that portion of his intestine back. And it's obvious because it's easily understood that if you lose a portion of something, whether that's a portion of your pinky or of your toe, that constitutes disfigurement. And it's the same. There's no difference between whether that's inside your body or outside.
Is there any case law that says that?
Well,
That's
to your
kind of what
point,
I'm curious about.
Yes, Your Honor. I was
Because
just
when we
going to
think
say.
about disfigurement, we think of something, we can see on the exterior of the figure.
Yes.
So how does that apply to internal?
Yes, Your
disfigurement?
Honor. This court has held that an injury need not be visible to the naked eye to be obvious. And while this court
Well, that's not
nor-
visible at all on the inside of the intestine.
Yes, Your Honor. What I was exactly, I was going to say that while this court nor the Tennessee Supreme Court has had occasion to exactly address this particular issue, other courts have. For example, the Georgia Court of Appeals in Weaver versus State a few years ago rejected the argument that, quote, to constitute serious disfigurement, the victim's injuries must be actually visible from outside of the person's body, unquote. And it held that, quote, damage to internal organs of the victim could constitute serious disfigurement, unquote. So other courts that have looked at this issue have held that, that injuries such as these, where there's a permanent loss, that first of all, we have uncontroverted lay testimony that occurred, so the loss occurred, and second of all, then kind of looking at that, then thinking about how multiple inches of intestine being lost, that constitutes both protracted, because it's permanent, as well as obvious, because it's an easily understood
But we haven't really addressed that
disfigurement.
in Tennessee.
That is correct, Your Honor. That is correct. While that is the case, other courts have come out the way of noting that would constitute. But there's also another theory the state has put forward in this argument as well, which is that the internal scarring also satisfies the protracted or obvious disfigurement requirement. Mr. Murphy testified that he required surgery because of the internal scarring. And contrary to my friend from the other side's position, this is something that the state has relied upon, that there were multiple surgeries, including the surgery to remove scar tissue that had wrapped around his intestine. We know based on the testimony and the fact that the surgeries were multiple months apart, that this constitutes protracted disfigurement. It was present for several months at least before it was then gone in and they took the internal scarring out. And to the point of that I mentioned earlier, this court has held that an injury need not be visible to the naked eye to be obvious. So this court has held on numerous occasions that scars are enough to constitute the protracted or obvious disfigurement requirement. So essentially, what the argument here is that internal scarring satisfies that requirement as well. But there's also a third way in which there is serious bodily injury, and that is protracted loss or substantial impairment of the function of a bodily member, organ, or mental faculty. Now, correctly, my friend from the other side focused in on function. What was the loss of functionality here? He was able to go in, he had surgery, they were able to repair it. So what evidence do we have? Well, the gunshot caused substantial impairment to the function of his intestines. How do we know this? We know this because doctors in an emergency surgery had to remove multiple inches of his intestine. The bullet was essentially lying on top of his intestine and had to be removed. And the jury could reasonably infer that the doctor would not have removed multiple inches of a vital organ if that was not necessary, if there was not a substantial impairment that essentially needed to be fixed in order for the organ to function properly. Now, there's kind of two parts to this. There's protracted loss or substantial impairment. It may be true that given the amount of time, there may not have been a protracted loss, but there was a substantial impairment here that needed to be fixed in order for his intestines to work properly. As the Manka Court held, any penetrating wound to the abdomen presents a substantial risk of death or protracted loss or impairment of the function of any part of the body, part or organ of the body. Unless there are any more questions on that issue, I'd like to move on to the consecutive sentencing issue. And just very briefly note that trial courts may impose consecutive sentences. They find by a preponderance of the evidence that one of 8 statutory factors are present. The court found 4 here. The primary argument that Washington is making is that the sentence was not the least severe measure necessary to achieve the purposes for which the sentence was imposed. And although the trial court did not expressly state that the sentence was no greater than Washington deserved, or that it was the least severe measure necessary to achieve the purposes of sentencing, not doing so did not constitute an abuse of discretion, because these considerations can be inferred based upon what the trial court found and the considerations that he made. In determining the sentence, the court considered the facts and testimony presented at trial, as well as the facts and testimony at the hearing, in addition to all the facts and considerations in the pre-sentence report. The court then determined that the 4 enhancement factors applied. Going through those, determined that no mitigating factors applied, as well as that 4 of the statutory factors applied, any one of which is sufficient for consecutive sentencing. As the Tennessee Supreme Court held in State v. Dixon, it is appropriate to impose consecutive sentences when a defendant has an extensive record of violent criminal activity in order to protect the public and to hold violent offenders accountable. And that is what the trial court was doing in this case. So for all of these reasons, the state would ask this court either to appeal the dismissal for failure to file a timely notice of appeal, or alternatively to affirm the trial court.
Let me ask you a quick question, General.
Yes, sir.
If my notes are correct, Mr. Washington ended up with an effective sentence of 63 years?
Yes, Your Honor.
All right, so the purposes, if this trial court basically said a primary purpose of me imposing sentence in this case is to protect the public from becoming victims of violent crimes by an individual who's demonstrated he's a violent criminal.
Yes, Your Honor.
And he's, I think, 42 years old.
Yes, Your Honor.
And so to me, if I impose an effective sentence of 63 years, he's 40-something now, and if he serves most of that 63, based on life expectancy, he won't be with us anymore.
Yes, Your Honor.
Therefore, the rest of his opportunities wreak havoc on society and with violent crimes will be virtually impossible.
Yes,
If
Your
I
Honor.
give him enough years. Now, I'm not saying, I've never read that in a transcript. But I'm just wondering if that was in a transcript, would there be anything erroneous about that for us? I mean, would we be required to say, based on any case law you're aware of, that factoring in life expectancies is just not the right thing to do? Or you shouldn't have done that, Judge. So we're going to have to send it back and let you figure out a different reason to put him away for a lot of time. What's your thought on that?
Yes, Your Honor. I don't think that is a requirement one way or the other as far as the trial court putting that on the record. I do think that the State versus Dixon case that I cited earlier is helpful on this. Consecutive sentences of, I believe it was 50 years. And in that case, the court still held that the consecutive sentences were appropriate based upon the extensive record of criminal activity, and that reasons that you can impose a sentence such as that include protecting the public and holding violent offenders accountable. And here we have an even more severe situation where the individual, Mr. Washington, had committed 15 misdemeanors, some of which were violent, half a dozen felonies, some of which were violent. Here, he shot a man while children were present, running around in the parking lot. It was a particularly egregious crime. Did not take any of that into consideration. He was on parole at the time that he committed this offense. And so I think taking all of that into consideration, which the court did, it certainly was not clearly erroneous to impose this a sentence of this nature.
I have not read what this trial court said. I was just curious when I read the case and saw the age of the defendant and the number
Yes,
of
Your Honor.
years and the numerous violent tendencies. Just was curious about, whether a trial court could basically impose a greater than the normal human life expectancy sentence.
Yes, Your Honor.
To try to guarantee the citizens would be safe from Mr. Washington.
Yes, Your Honor. And this court has held, such as in State versus Johnson, it affirmed an effective 70-year sentence. And so that is certainly something that sentences of that nature, just because, I guess the point there is just because a sentence is that long does not inherently mean that it's clearly erroneous to impose it.
All right, thank you.
Thank you.
Something tells me you might have a different view about my hypothetical. Don't feel required to answer, though.
I have a few different views, I suppose, Your Honor. I would say on the consecutive sentencing, the record will bear out the trial court's language. And our position is the trial court did not put sufficient reasons to support an effective life sentence
I
here.
know there are a lot of other factors involved, not just
Of course.
how old he is. Go ahead.
Yes, Your Honor. A few points on the serious bodily injury issue. Number one, I want to be clear on the Menka case that the state referred to a few times. That is out of Nebraska. It is designated not for publication, just like our unpublished opinions are. But that case in particular also says do not cite except pursuant to a certain Nebraska rule of procedure. Even setting that aside, though, the Menka case is the one where the court, Nebraska court, said that any penetrating wound to the abdomen creates a substantial risk of death. Number one, we have the citation problem. Number two, it's out of state. Number three, that's just contrary to Tennessee law. Farmer and Prescott say exactly the opposite. You have to look at the actual injury that occurred, not what could have occurred. So Menka, even if it could be persuasive to this court, is so far afield from established Tennessee law, it does not control here. The other state cases that the state has relied upon here, as I said, most of them are unpublished. And in many of those, they actually had medical experts who testified about the location of the wounds and why they were concerned about the location of the wounds, which we don't have here. The state has no Tennessee law about internal injuries. The cases that it does cite, Champion specifically, the victim was hospitalized for at least a week. I will defer to the record. I do not think that Mr. Murphy testified or that there was any proof that he was in the hospital for at least several or multiple days, as my friend on the other side said. I don't think that's borne out by the record, but if it's there, it is there. But as to Tennessee case law about disfigurement, the two cases we have, Blue and Reese, are about visible external scars or disfigurement. The out-of-state cases that the state relies upon, Weaver out of Georgia, and I can't recall the other state where the other one was from, but in those cases, there were internal injuries, but additional proof about the effects of those injuries. So one of the victims was bedridden for 2.5 months because of a broken pelvis and internal breaks, which makes sense. We don't have that here. As far as the perforation to the GI tract, what the state has described as a hole in the intestine, frankly, I think that's pure conjecture based on the record that we have here. If a medical expert had testified to that, fair enough, but we don't have it here. And I think that's the final point, if I could end on that, because we ended our reply brief on this point as well. The state is effectively asking the court to uphold this finding of serious bodily injury based on what the state called a reasonable inference. And our position is there's a reasonable inference is one thing, but proof beyond a reasonable doubt is something else. And the state did not do that here to prove that the actual injury that occurred in this case qualified as a serious bodily injury. They could have, they did not, and therefore we're asking the court to find that the proof did not support the finding of serious bodily injury. No matter what we could assume or conjecture up, the proof simply was not there in this case. Thank you, Your Honors.
All right, thank you. Call the next case, please.
Curtis Keller versus State of Tennessee.